Hello from Gilbert and Tobin. I'm Moya Dodd.
And I'm Matt Rubinstein, and this is The Competitive Edge, what you need to know about competition law in Australia and around the world.
Today, 2026. Partner Elizabeth Avery joins us after a world tour of competition law to talk about new directions in antitrust, theories of harm, and merger review, both here and overseas, now that the World Cup is over and we don't have to get up quite so early anymore.
I think some of the so-called new theories of harm might not be that new. So, for example, the ecosystem theory of harm, which relates to digital platforms largely, is really a reheated, or another word for the old conglomerate effects. It's really not that different.
But first, Matt, everybody knows, or they should know, that 2026 is a BBC Two mockumentary about the planning of the 2026 World Cup.
Yeah, though they do have this conceit that they're not allowed to say World Cup or FIFA. They have to beep it all out.
Well, maybe we should bleep it out from now on. The Men's Cup?
Yeah, they also bleep out Gianni Infantino, the 14th in Pope Leo the 14th for some reason, Trump and Truth Social, and then they separately bleep out first the 700 and later the million in 700 million, which is the value of their contract with Adidas, which is also bleeped.
Ah, well, that's the old redactors problem. If you don't get everything right, you can ruin it all.
Very true. And this is a follow-up to 2012, which was about the London Olympics of that year, and also W1A, which was all about the BBC.
Yeah, and Hugh Bonneville plays basically the same character in all of them with different ridiculous job titles. And David Tennant narrates them all with his own Scottish accent.
He does. And best of all, for our purposes, the theme music is Mambo No. 5, or Repo No. 5 as we know it around here.
So I think this is the Perez Prado original from 1949, which doesn't have the problematic lyrics of the Lou Bega version, or the impeccable lyrics of our version.
Yeah, I think that's right. The series has some clever retconning about how the final matches ended up being where they were, but they did manage to predict the heatwave a whole year in advance.
Well, that was probably predictable, but now that the Cup is over, what's been happening around what's left of the grounds?
Well, we're well into the second half of the first year of the mandatory merger review framework, and there's plenty of news about the phase twos that are joining the acquisitions register or leaving it in quite a surprising variety of ways.
Yeah, we've now seen the first rejection of a merger by the ACCC under the new system.
We have, and it's our old friend, the new Coles supermarket in Kalgoorlie.
Yeah, so Coles already has a supermarket in Kalgoorlie, and it wasn't proposing to buy another supermarket or even an existing supermarket site.
No, it's just the lease of an empty site, which, if it wasn't a supermarket, could well be in the ordinary course of business or under the thresholds and not subject to review at all.
But under the new merger regime, the major supermarkets have to notify the ACCC of any acquisition of a lease of vacant land over 2,000 metres squared, even if the other thresholds aren't met.
That's right, and Coles actually notified the ACCC voluntarily about this lease last November, probably because there wouldn't be enough time to get a resolution under the old informal regime.
Well, normally the addition of a new supermarket might mean an increase in competition, wouldn't it?
It normally would, but here the ACCC decided that if Coles built this new supermarket, one of the existing supermarkets in the area was likely to exit the market, partly because the population of Kalgoorlie isn't really growing very much at the moment.
Yeah, they said that while the new Coles would increase competition when it opened, it was also likely to lessen competition later on when that other supermarket was forced to close.
Yeah, and they said that was likely to be an independent supermarket that had a differentiated offering that was valued by consumers.
And is that supermarket the Spud Shed?
Well, we don't know. It's just called the relevant independent in the determination. But the Spud Shed probably has the most differentiated offering. It's open 24/7 to accommodate the shift workers at the nearby super pit.
And we know that nowadays an acquisition that would create, strengthen or entrench substantial market power could well be likely to substantially lessen competition.
Yeah, and the ACCC doesn't use those exact words in the determination, but it does say that if Coles gets a new store and an independent competitor has to exit, then that would give Coles a substantial degree of market power in Kalgoorlie.
And Coles has now applied to the Australian Competition Tribunal for a limited merits review of the decision, and it's also applied to the Federal Court for judicial review of the ACCC's decision on procedural issues. So these are two more firsts for the new merger regime, and they're pretty big ones.
They are, and they've already had a directions hearing on both applications before Justice O'Brien, who's president of the tribunal as well as a justice of the Federal Court. And he wasn't a big fan of those dual and potentially dualling applications and had some questions about how they're going to line up.
So Coles has sought to stay the court proceedings until the tribunal proceedings are done, and then if the tribunal upholds the ACCC's decision, then they'll go back to the judicial review.
Yeah, so this really is belt and braces.
Is it having your cake and eating it too?
Your Coles celebration cake, for example.
And His Honour has sent Coles off to think about that and make some submissions.
Yeah, and it'll be really interesting to see how this plays out, whether they'll get to introduce any new evidence, what the process looks like, and whether they'll go on a view to the super pit. The judge says he's already spent some time there and kind of knows the lay of the land, but the lay members might feel differently.
Well, getting back to the acquisitions register, I see we've also had our first two Phase 2 withdrawals.
We have. So Peter Warren has withdrawn its acquisition of car dealership sites from Wakeling Automotive Group, and Treskel and TR Calibration have also left the field.
And who's Peter Warren, Matt? Any relation to Ray Rabbits Warren?
Well, I don't think so, but Peter Rabbits Warren would be even better.
Yeah, it would. He could even be Peter Rabbits Warren.
He could, but the ACCC raised some concerns about his acquisition of Wakeling, so he's walked off the lot. But he's now lodged a new notification with a remedy offer that would divest 8 of the sites, and that offer is now open for public consultation.
And the second withdrawal is Treskel and TR Calibration, who both supply calibration services. What are those services exactly, Matt?
Well, calibration services involve calibrating things that need to be calibrated.
And what can those things do once they're calibrated?
Well, they can calibrate other things, or they can test or measure things that need to be tested or measured by things that are calibrated.
Well, the ACCC had quite a long list of matters it intended to investigate in Phase 2. So have the merger parties, recalibrated their expectations?
Well, it looks like they've stepped back from the merger, at least for now. Interestingly, they didn't formally withdraw, they just didn't pay the fee by the due date, and so their assessment is now listed as ceased.
Oh, but just ghosting the ACCC like that? Is that what we used to call taking French leave?
Yeah, though in French it's called partir à l'anglaise, to leave in the English style.
You mean like what happened to France in the semi-final?
Too soon, Moya. But so far we have 1 Phase 2 that's been cleared, 1 opposed, 2 are ceased, and there are now 4 that are still under assessment.
And we've spoken about the Microstar and Convoy beer keg merger and the IAG and RAC insurance merger, both of which were opposed under the old informal merger clearance process.
They were, and they're now still in Phase 2.
Okay.
But we also have 2 new Phase 2s, starting with the proposed acquisition of Subsea 7 by Saipem.
And the ACCC describes both of those parties as global engineering and construction companies that provide services for offshore oil and gas projects.
Yeah, and the ACCC has found quite a few areas of concern. It says they're both key suppliers to offshore Australian oil and gas producers, and they both operate the vessels used for those services.
And they both supply infrastructure that connects subsea wells and production systems to surface facilities.
Yeah, and they both supply the same kind of services to offshore oil and gas projects and wind farms. But the ACCC isn't proposing to consider those last overlaps any further.
They probably ran out of amber lights.
They must have. The ACCC also notes that these services include various methods of pipe lay, including flex lay, S lay, J lay, and reel lay.
What way the hell, hey?
Exactly.
Wasn't Subsea 7 a British pop group in the 1990s?
Well, there was S Club 7, though you might be thinking of 07 or even L7.
Or 007. Isn't L7 a vertebrate?
It is, but not usually in humans, more in cats and dogs.
Well, the other new Phase 2 is the Zoetis acquisition of Neogen's genomics business.
Yeah, the ACCC says that they're the 2 largest suppliers of genomic testing services for cattle in Australia.
Well, we've all heard of the Human Genome Project. What is this, the Bovine Genome Project?
That's exactly what it is. The Bovine Genome Project was completed in 2009 using a female Hereford cow named L1 Dominette 01449.
Oh, why couldn't it have been L7 Dominette 01449?
It should have been. But genomic testing can now identify genetic traits like fertility, growth rates, milk production, meat quality, disease resistance, and overall health. And those are all economically important characteristics, as you can well imagine.
Yeah, so the ACCC is looking at whether there are alternatives to genomic testing and whether there will be new entry in the market and so on.
Yeah, so this is Old MacDonald Had a Farm, TACAGGAATGGGAGCTGTG.
This is really part of the bovine genome, is it?
It is. It's the part that codes for the bovine growth hormone.
Oh, well, I knew that. So before the new regime started, the ACCC said that in the first 12 months, so from July last year, it expected there'd be 8.5 Phase 2 reviews, with 15 each year after that.
Yeah, and in the end, 6 matters moved into Phase 2 during the first year, so that's not far off, even though 2 of those then withdrew quite early on.
Maybe those were the 0.5. But we've already had 2 phase 2s in the first month of 2026-27
Yeah, so that is on track for 15 over the year.
so far. What else is going on?
So we spoke last time about the new exceptional circumstances framework, and the Treasurer has now issued the first exceptional circumstances declaration.
And the exceptional circumstances have to be the disruption to global supply chains arising from the conflicts in the Middle East commencing in February 2026 and the disruptions to international shipping transport through the Strait of Hormuz, right?
Exactly right. The declaration was made on the 23rd of June and it wasn't backdated, so it starts on that date and it's going to end 6 months later.
And the ACCC's class exemption was made a week later, and that was backdated to align with the declaration.
It was, and the class exemption applies to government meetings and non-government meetings held for the purposes of responding to or recovering from these exceptional circumstances.
And it covers preparing for the meeting, participating in the meeting, subsidiary discussions, agreeing to a plan and implementing a plan.
Yeah, but it doesn't cover agreements on the price of goods or services where the parties compete with each other.
Okay, so price fixing is a no-go, but you might get away with what? Some market sharing, output restrictions, or maybe some light bid rigging, Matt?
Well, maybe, but they'll have to notify the ACCC of any of these meetings, including who's coming and what they're discussing. A lawyer approved by the ACCC has to keep an eye on things, and the ACCC has to be able to attend if it wants to.
And the ACCC has to be notified about what the plan is and, in some cases, to give its approval for particular businesses to be part of the plan.
Yeah, so that's all pretty straightforward, and it's nice to see that the ACCC is making sure that there's a role for us lawyers.
Time for another?
Well, the National Anti-Scam Centre has just announced a new fusion cell and a new portmanteau, and it's scambling, which is where Australians are being lured into fake online gambling and casino platforms that manipulate results, withhold winnings, and incentivise users into recruiting other people.
Yeah, and ScamWatch received 806 scambling reports in 2025, up from 677 the year before, and reported losses more than tripled from about 450,000 to 1.6 million.
Yeah, and those figures are likely to underestimate the real losses, including whether victims think they've just lost money through gambling and not through a scam.
Well, the ACCC reminds us that licensed online gambling operators in Australia can offer sports and race betting and lotteries, but that's it. Online casino games, real money pokies or in-play betting are all illegal and are likely to be scambling.
Yeah, and you can check the ACMA website for licensed interactive gambling providers.
Do we need one of those gambling disclaimers to say that?
Well, only if we're advertising or promotional materials, which I don't think we are.
Do you remember Betterkit? I think that was in New South Wales.
Of course, show some Betterkit, betting with good old-fashioned etiquette.
And isn't Betterkit another portmanteau?
Absolutely it is, Moya. Betterkit must be like the opposite of scambling.
And wasn't the word portmanteau coined by Lewis Carroll in Through the Looking Glass in 1871?
It sure was. He invented chortle in that same book. But portmanteaus have been around for a long time. Oxbridge was in print by 1849, Brunch is from 1895, and Spork has been with us since 1909.
Well, even podcast is a portmanteau, isn't it? From iPod broadcast?
It probably is. And, you know, the last new iPod was sold in 2022, which means that the podcast has now lasted longer than the iPod, with plenty of life left in it yet.
Let's hope. But are there any portmanteaus in the merger review?
Well, I guess there's acqui-hiring, or more recently, acquisitions.
And in consumer protection, I guess there's shrinkflation.
Of course. And a lot of mergers do result in portmanteaus of one kind or another.
Yeah, like Para, Sky, Warbro, Disco.
That's the perfect example. And Moya, you recently sat down with partner Elizabeth Avery, who's come back from a tour of key antitrust jurisdictions and has a lot of reflections on the way competition law is going here and overseas.
I sure did. Elizabeth had a lot to say about the Paramount merger, the Coles lease, the latest changes to our merger laws and the way politics is battling with economics in competition law.
Let's take a listen.
I'm very pleased to welcome back to the pod Elizabeth Avery, the Group Leader in Competition, Consumer and Market Regulation here at G&T. Aside from being very busy with the new merger regime since the beginning of the year, Elizabeth has been to a few international gatherings, including the ABA in Washington, the Cambridge Forum in the UK, and the European Competition Forum in Brussels. I'm not quite sure how you managed to fit it all in, but it's great to have you back, Elizabeth. Welcome.
Thanks, Moya. Lovely to be here, and I do like being on the ground in Sydney.
Indeed. Can I ask you, first of all, what international trends you're noticing? If we were to take a bird's eye view of antitrust around the world, what are you seeing there?
Yeah, I guess one of the things that everyone is talking about is what is the impact of politics and what is the role of politics in antitrust regulation. In the context of antitrust law, I suppose there's one school of thought that thinks, what are you talking about? Antitrust is just about economics. It's got nothing to do with politics, policy. It's just about enforcing a statute which is an economics-based statute. That's one extreme. And another extreme, it is a creature of industrial policy. And there's, some regimes like China where that's explicitly the case. But probably somewhere in the middle, and where most countries and people would settle in, is that actually it's a policy. It's for the benefit of consumers. That's not always objectively ascertainable by reference to some objective economic criteria. And around the edges, there's room for subjectivity on that. So whether you call it politics or policy or subjective views, there's always going to be an element of the political. Now, whether or not that is politicised is another question. And I think that is the great question that a lot of people are raising lately. Has antitrust become politicised?
These days it feels that there is a lot of polarisation of views, that the rule of law is somehow less respected, that it's not as clear that precedent will be followed, for example, particularly in the US, when you look at the Supreme Court and some of the decisions made there recently. So it's understandable that this question would come into focus right now.
Yeah, it is understandable. And I think there's a lot of questions about what direction different agencies are going in. And, for a long time, I think there has been convergence of views around what antitrust law means and how cases should be interpreted. And perhaps there is more divergence now.
And the economic situation that we're facing, there's the Iran war, the
Ukrainian
fuel supplies,
war.
the Ukrainian war, climate issues. There are a lot of economic challenges arising from the things that we're facing into in this world, that I guess that bleeds into policy decisions like this as well, doesn't it?
Absolutely. I suppose what we've seen is that in different jurisdictions there might be influence by particular leaders. In the UK, they've very much considered that the CMA, the Competition and Markets Authority, had gone too far in regulating mergers that had little impact on the domestic UK economy. There was a change of leadership at the top of the CMA, and the government actually gave what they describe as a steer to the CMA, and that is all about making sure that the CMA takes into account productivity in its decisions, not just competition. Now, they're two sides of the same coin, arguably, but the government wanted explicit consideration of the impact of decisions on productivity in the UK economy.
So they were putting a thumb on the scale, perhaps, with some of those productivity elements that might feed into a competition test.
That's right. But, it was quite unusual for a government to intervene in that way and give a so-called steer to the agency. And there was, change at the top because of perceived impact that the agency was having on significant matters to the British economy.
People talk about national champions now and, protecting major industries within a national economy. Is that something that's shining through in what you're seeing?
Look, I think that, there was the Draghi report a few years ago in Europe, and I think in other countries implicitly that concept is there. Definitely is in China, for example. The ACCC and successive chairs of the ACCC have constantly disavowed the notion of a national champion. But more recently, I think Europe has embraced the need for a more competitive and productive Europe to compete with the rest of the world. And it's perceived that it needs to consolidate within Europe to enable it to compete against other parts of the world. So I think it's probably the most explicit example of embracing a national champion. The concept of a national champion can be really at odds with competition, because what you're saying is that your domestic competition for consumers can be sacrificed in the name of ensuring that there's one strong local manufacturer, for example, to compete with the rest of the world. But in the process of that, what does that mean? That means that consumers are going to suffer because consolidation is permitted to enable the national champion to compete on a world stage.
Is any of this a reaction to the US tariffs, do you think? The sense that others have to kind of muscle up and be able to defend themselves in a world where free trade is not apparently a priority anymore?
I think the concept actually predates, and the Draghi report predates, the current president of the United States announcement of tariffs. But that announcement probably is inspired by the same concern that China, for example, and other economies are so big now and they have their own national champions that it is very difficult for these other economies to compete. And I suppose the Trump administration's announcement of tariffs gave some legitimacy to the concept that it is okay for a nation to defend its economy by rising above and perhaps imposing regulations and or ignoring regulations that might impact its ability to be a strong competitor on the world stage.
Can I ask you now about theories of harm? Because we've seen a few new ones emerging in recent years. What are you observing in how they're expressed and how they're applied around the world?
I think some of the so-called new theories of harm might not be that new. They're revived old theories of harm.
They're reheated?
With new names. So, for example, the ecosystem theory of harm, which relates to digital platforms largely, is really, as you say, reheated, or another word for the old conglomerate effects. It's really not that different. You can really apply the same lens of analysis around leveraging and foreclosure and adjacent markets and what impact you can have in one market from another. But it does attract a lot of attention. And I think largely the conglomerate effects theory of harm had been discredited in most cases.
Oh, well, then it needed a new name.
It needed a new name. And it all of a sudden, we are seeing a lot of consideration at an international level of an ecosystem theory of harm and what that means, particularly in the digital context. And you've, of course, got some bespoke digital regimes now with the DMA in Europe, and also the UK has recently introduced its own regime. So we are seeing those theories of harm being increasingly alleged.
And in Australia, with the amendments here, we've seen entrenchment of market power.
So the concept of entrenchment is new under Australian law, or at least explicit recognition of it is. The ACCC says it is mere clarification of what the SLC test is, but nevertheless it does seem to bring up elements of our old dominance test back into what is now otherwise a substantial lessening of competition test. And so effectively what it does is it means that if you're a dominant company and you acquire a small firm, there is a theory of harm that relates to you entrenching your dominant, building defences, if you like, around yourself to prevent competition. That theory is actually at the cutting edge of theories globally at the moment, and we've seen that theory also in the 2023 merger guidelines that were enacted in the US before the Trump administration came into power. And there's a whole guideline that targets mergers that entrench or extend a dominant position. And then most recently, earlier this year, the European Commission released some draft merger guidelines. There's an extensive discussion about entrenchment theory, including across interconnected markets and ecosystems.
I wonder how much of this is a reaction to a sense that new competitors are emerging rapidly in the digital landscape, and a sense that everybody needs to do something to regulate these people. We need some new laws. We need some new tools in the toolbox for regulators. So these new names have come forward for what are essentially old concepts that are maybe they're sharpening the old tools that they already had.
That's quite possible. The other aspect and element of it is, I think, a presumption that if you're big, you've got market power and any merger is presumptively bad. I think there's a tendency with an entrenchment theory of harm to jump to that conclusion. So I think it does make it more challenging for larger companies. Of course, there are good reasons why a large company might need to make an acquisition, and it might be much more economically rational for it to acquire a capability that it would not otherwise be able to develop effectively internally. But I think that the theory starts from the presumption that a big company is buying up someone nascent or small to entrench its market power and stop disruption.
Whereas what it does is perhaps feeds an ecosystem so that those smaller entities come into existence and they have a business model that enables them to be acquired by someone who is able to take and scale the technology that they develop.
Quite. I think I've said on this podcast before, there are a lot of startups that come up with a great idea, but for them to take it to the next level and distribute that broadly is actually not their skill set. There's a bunch of engineers in a garage who have the highest IQs on the planet coming up with fantastic innovations, but their interest and their skill set is not in making it broadly available across the economy. And actually sometimes you need that larger platform to enable that to be harnessed.
The acquisition of small companies is one way in which competition can legitimately occur, especially in technology industries. Are you seeing much around the concept of innovation and competition internationally?
Yes, absolutely. It's something that has been under consideration from a lot of, particularly the EC and the US for many, at least the past 5 years, where they consider not only the traditional impact of a merger on price, but also on innovation. So what we're seeing now also by the ACCC, but in Europe and the DOJ, is they regularly ask for merging parties' innovation pipelines. So that's particularly common in pharma mergers, where they have drugs in clinical trials, for example. But, there's a lot of innovation that never makes it out of the incubator too. So you do have to be careful about weighting innovation and R&D investment too heavily, because you can have an early stage experiment that is light years away from actually becoming anything that is remotely commercial. But we are seeing increasingly that extending beyond pharma to sort of mainstream mergers, and a lot of mergers in the digital space and a lot of AI-related products. We're absolutely seeing the ACCC following other regulators in asking detailed information about companies' innovations.
So how do they process that? So, let's say they ask, well, show us your pipeline of innovations. What does that tell them? How do they assess that in deciding whether or not competition will be lessened through that merger?
That's a really good question, because they have to assess the likelihood. So, for example, if you have company A acquiring company B, company B has an innovative product, but company A has some R&D internally, which, if it ever came to market, might compete in some way with the innovative product that is being acquired.
So they look for overlap.
They're looking for overlap or some
markets.
vertical relationship, etc. But what they need to test is what is the likelihood, one, that the innovative product of the acquiring company will ever come to market. And if it does come to market, then it needs to assess in that future, what's the world going to look like, and are there going to be alternative products out there?
Well, back at home, of course, we've got new merger rules here that have been in force for a year now, partly mandatory and partly not. And you've clocked up some miles yourself on dealing with these mergers, in particular Paramount. You recently advised on this matter and won ACCC approval. What are you able to share with us about the key issues for the ACCC and how you won them over?
Thanks, Moya. Yeah, it was a great one to be involved in, and it was really pleasing to be able to get clearance in phase 1. I think we were the first main regulator around the world to clear the transaction. So that
beat the clock.
So I think the new merger process actually worked. We spent quite a bit of time in pre-notification, providing the ACCC with a lot of information. We provided more information once we were on the clock, and the ACCC did really test us and the issues very closely. But I found the whole process of dealing with the ACCC very constructive. They were as transparent as they could be. They gave us a letter outlining possible concerns, and it provided us with the ability to respond. And we did that all within 30 business days of being on the clock. And the ACCC then issued a very detailed decision. The main area of its focus was whether the acquisition was likely to substantially lessen competition in relation to production, licensing and wholesale supply of films for theatrical release in Australia. And the ACCC tested all of the issues really closely, but that was the main issue. And the other issues that they considered were whether there were potential horizontal effects in relation to the wholesale supply of non-theatrical AV content, whether there were potential unilateral horizontal effects in the supply of streaming services, the potential for the merged entity to leverage its position in its downstream retail services, such as streaming, to foreclose rival suppliers of wholesale non-theatrical AV content, and the potential for horizontal effects in the acquisition of AV production services in Australia, as well as the potential for unilateral horizontal effects in the supply of advertising space. It really did look very broadly, but the ACCC dismissed most of those theories early on as they were not supported by the material that the ACCC received.
So they felt that those markets were competitive. Is that fair to say?
Correct, that's fair to say. And that at the end of the day, they felt that there was no substantial lessening of competition in any market. But the main focus was in considering how the parties competed in the supply of films for theatrical release in Australia.
So movies in movie theatres, all the streaming TV shows, all that stuff didn't really cause any concerns.
Yeah, well, the concern, exactly, that's so fragmented in Australia. But of course, once upon a time, you had everything being distributed in theatre. And so the ACCC was really trying to come to grips with what it meant for theatre distribution.
And they concluded that the business of movies in theatres was sufficiently competitive that this was not going to cause any...
Yes, there are a number of factors that went to that, but it considered while the acquisition would, of course, remove competition between Paramount and Warner Brothers, the merged entity would continue to be constrained by other film studios after the acquisition.
Yes, indeed.
I mean, actually, in Australia, Warner Brothers films were already being distributed by another major, so it wasn't really a contraction of competition. It was just shifting from one distributor to another in a way. But the process was constructive, and I think a great example of how the process in Australia can work extremely well in the context of a very significant global transaction.
And of course it is still ticking along in other jurisdictions. The ACCC's got to its conclusion first. Are there any reflections on the differences of other jurisdictions and how they affect global mergers that have already been cleared in Australia?
I think you have this interesting dispersal of power of the agencies in the US. So you have the Federal Trade Commission and the Department of Justice, who both review mergers, but they sort of pick between them who's going to review what. But then, of course, you have all the state attorneys general, and they have independent power to review mergers. And so in the United States at the moment, while it has been cleared at the federal level, there are state AGs who are currently contesting the merger. So that process is ongoing.
Well, Paramount was something you got done in phase 1, but there's a few matters going into phase 2 now, and we've seen our first rejection under phase 2.
Yeah, it's a really interesting case actually, Moya. It's about Coles' potential acquisition of a greenfield site in Kalgoorlie, that is acquisition of a site to build a new supermarket, so add more competition, arguably, to the Kalgoorlie market. But the ACCC considered that it would do the opposite because given the limited growth in Kalgoorlie, the ACCC's view was that it would diminish competition because another competitor would be forced to exit. And the ACCC considered that that other competitor provided a diverse offering to consumers, offering broader choice. Now, you might say, well, shouldn't the market decide and consumers decide whether they want to support that other supermarket to stay in the market rather than Coles? But the ACCC has decided that the value of choice should be in its hands, and so it's blocked the merger. I know they've filed an application for review in the tribunal. It will be the tribunal's first review, so it will be really interesting to see how that unfolds. And it's really dealing with some very fundamental issues in competition law and policy about protecting competition versus protecting a competitor, whether they're diametrically opposed or whether they're the same thing. And Coles has also lodged an application for administrative law review with the federal court. So that's interesting because what we'll have is a concurrent tribunal review on the merits and a federal court review of the legal aspects of the ACCC's decision. It's really important to get this early guidance from the court and the tribunal, so we're all eagerly awaiting the next steps.
And all of that has come out of a plot of land in Kalgoorlie.
Yeah.
Amazing. And we're now looking into some more amendments to the regime with void and voidable and a few other things. Would you look back on this period and think it's been a good transition from the old regime to the new, or is it something that everyone is having to work doubly hard to make function?
I think any transition is not going to be completely smooth. So I don't think it's probably realistic to expect that it would be BAU and we'd all just adapt day one and that the legislation would work perfectly. I think what has been good is that the ACCC and the government have been willing to engage in discussions about some aspects that don't work so well. Some of those problems the government doesn't feel it can deal with right now, but others it has. And as you mentioned, the change from void to voidable, which I think is a small change, but potentially an important change. So at the moment, if a transaction is not notified, and it ought to have been notified under the law, it is automatically void. And so that means you might discover when you're doing due diligence on a company several years later that there's a transaction that they didn't notify and they ought to have, and that transaction is automatically under the law void. Now, I think the intention, you think, why would anyone introduce a law like that? I think the intention of that was to make the penalty for non-compliance much, much more than just a big speeding fine.
Right. But so in other words, when we say mandatory, we mean mandatory.
Exactly. But the problem with that is, of course, there are a lot of unintended consequences and innocent bystanders who are affected by that. And you think about all the employees in a company, all the counterparties to contracts with a company that might not exist because the merger is void.
And with real estate too. I mean, normally if you have a certificate of title to something, then it is a guarantee that you own that real property.
Under the Torrens title registration system.
Right.
Does.
But if you have now discovered that that transaction was void, then what's the use of your certificate of title that you've been waving around for the last 5 years?
It's sort of like old system title, Moya.
Yeah, it does. It takes us back to the Middle Ages, doesn't it?
Needing to trace back and ensure all of the transactions and preceding transactions were valid. So it was a real problem. And so the bill that's currently put for Parliament will change the law from void to voidable, which means that the ACCC has to go to court and have it declared void for it to be actually void. Now, there'll be some prosecutorial discretion there where the ACCC might not decide to go to court over a transaction that is technically void. The ACCC has indicated that they are going to set out guidelines so that we can work with that. The court is not allowed, however, and explicitly so in the legislation, is not allowed to consider the impact of competition caused by the transaction in determining whether to grant the order declaring the transaction void, which is a bit of a shame, right? Because it seems to be then overreaching into transactions that are completely benign. The other side of the coin is that what the government's trying to do is encourage people not to use this court method as a backdoor
escape hatch.
Exactly, saying, well, we won't notify because we'll have the ability to go to court and argue that it doesn't substantially lessen competition. That would be unfortunate. An alternative would have been to allow the court to remit the case to the ACCC for the ACCC to consider through its usual process whether it should be approved or not. But the government chose not to introduce such a provision at this point in time.
Interesting. Well, there's always something more. There's always another chapter in this story. But it's been terrific having you today, Elizabeth, to share the view from the top, globally and here in Australia.
Thanks, Moya.
What a great interview. And speaking of Parasky Warbro Disco, the District Court in California has now issued a temporary order to stay that merger, and the parties have agreed to a longer stay while the case brought by the State Attorneys General plays out.
Yeah, and they're looking at June next year, potentially, unless the court can make its decision sooner.
Yeah, and look, the merger approval landscape is pretty complex here in Australia, but at least we don't have 2 antitrust agencies and 50 state AGs to deal with.
Indeed. And speaking of movies, Matt, have you been to see the new Christopher Nolan movie, The Odyssey?
I'm actually going to see it on the weekend, Moya. I wanted to wait until there are seats available at the IMAX here in Sydney.
Well, I thought the thing to do was to go and see it at the IMAX down in Melbourne.
Well, it is true that the Melbourne IMAX is showing a 15 perforation 70mm film print of the movie, which is 17 kilometres of celluloid and weighs over 200 kilos. And Melbourne's the only cinema in the Southern Hemisphere to have that copy of the movie or the ability to play it.
Well, what about the Sydney one?
I'm glad you asked. That's using a dual laser digital projector setup, which isn't quite as good, but the tickets were expensive enough without adding a round-trip flight to Melbourne.
Well, I guess with the money you save on the flights, you might be able to buy some IMAX popcorn.
Just about. Actually, one of my first jobs as a lawyer here was to fly to Melbourne, get a taxi to the IMAX cinema there, and hand over a cheque for a purchase of all the IMAX cinemas in Australia. Then I flew straight back again without even watching a movie.
Well, we all know that the Odyssey is Homer's epic tale that takes place after the Trojan War, which was described in the Iliad.
That's right. And spoiler alert, it takes Odysseus 10 years to get home from the war because that's how long it took for him to cancel his Amazon Prime subscription.
Of course, the Iliad flow.
Exactly. But it seems like some people out there can't even be bothered to go to the cinema because Universal has had to get the federal court to require our internet service providers to block access to terrible copies of the Odyssey that some people might want to download and watch on their phones.
So Section 115A of the Copyright Act has allowed for urgent site blocking injunctions for about 10 years now. But is this the first time it's been used in relation to a specific movie?
As far as I can tell, it's the second time. So last year it was used ahead of the release of Wicked for Good, the second half of the musical prequel to The Wizard of Oz. And in both cases, it was Universal that applied for the injunction.
Okay, and Universal don't have anything to do with Paramount or Warner Brothers, do they?
They don't, though most of Christopher Nolan's previous movies were produced by Warner Brothers, but the last two weren't, apparently because Warner wanted to stream them on HBO Max during COVID.
All right, well, now I know how Odysseus felt. Remember, you can find relevant links in the show notes or email us at edge@gtlaw.com.au.
And if you enjoyed today's episode, please subscribe, leave us a review, and tell your friends.
Till next time, this was The Competitive Edge with Gilbert and Tobin.